Good afternoon, everyone.
Good afternoon, ma.
Sorry, it has been network failure on my own side. I've been trying to catch up with the network. Milord is online already, and the ruling is ready. Please, is everyone there? Kindly respond and announce your appearance, please. This case between Martins Wadu and Laser Engineering.
Yes, we're here. Can I go on?
Yes, announce your appearance.
Okay. May it please, Honorable Court, I am O.E. Adedoja. Adedoja is spelled Adedoja. And I appear with D.O. Ogenemiro. We both appear for the claimant in this case.
First, second, and third defendant. Kindly announce your appearance.
If it pleases the court, CCOK.
You are all the registrar, all the counsel are online?
Yes, my lord, they are online now.
All right. Parties absent?
Yes, my lord.
Yes, appearances, please.
May it please, Honorable Court, I am
Yes.
O.E. Adedoja, my lord.
Yes.
And I appear with D.O. Ogenemiro.
With who?
D.O. Ogenemiro. Ogenemiro is spelled D.O. Ogenemiro. Ogenemiro is spelled O-G-H-E-N-E-M-A-I-R-O. We both appear for the claimants on record, my lord.
Yes.
Grateful.
Yes, first defendant.
If it pleases the court.
Yes. C.C. Okere.
Yes, my lord. I humbly appear for the first defendant.
Yes. Yes, second defendant. Second defendant. Registrar. Hello, second defendant.
My lord, I'm here.
Yes, announce your appearance. Second defendant.
My lord, I'm E.O. Princeway.
Yes.
E.O. Princeway for the second defendant, my lord.
Yes. Yes, third defendant. Third defendant. Registrar. Third defendant. Yes, registrar.
My lord, third defendant is on mute. He has to mute so that we can hear him.
Okay. So he's online. I cannot see him. That's why I'm.
He's online.
My lord. Yes.
If it pleases my lord.
Yes.
My name is A. Olungwe for the third defendant, my lord.
Yes. Yes, as promised, the matter is for ruling and the ruling is ready. Yes, I will read it. This is motion on notice filed by the second defendant applicant on the first day of September 2025. The motion was brought pursuant to Order 11, Rule 1, Sub-Rules 1, 2, and 3 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, and under the inherent jurisdiction of this Honorable Court in Section 6, Subsection 6A of the Constitution of the Federal Republic of Nigeria 1999 as amended. The applicant seeks the following reliefs. 1, extension of time to seek leave to set aside the order of foreclosure made on February 13, 2025. 2, an order setting aside the order of foreclosure made on February 13, 2025. 3, an order granting the second defendant applicant leave to call Nnamdi Ezenwa as substitute to Mr. Henry Ochenna Ezenwa, listed as second defendant witness. 4, an order deeming the said written deposition filed separately as properly filed and served. And 5, and for such further order or orders as this Honorable Court may deem fit to make in the circumstance. In response to the motion, it was supported by affidavit and also a written address. In response to the motion, the claimant respondent filed a counter affidavit on the 8th day of September 2025, together with a written address in opposition to the application. The claimant later filed a further affidavit in support of his counter affidavit on the 21st day of October 2025. The first defendant did not file any counter affidavit, but raised objections orally during the hearing of the application. The third defendant informed the court that it was not opposing the application, but asking for cost since, according to the learned counsel, had already filed his final written address. After consideration of parties' written addresses and oral submissions for and against the application, this court distilled a sole issue for determination as follows: whether the second defendant applicant has placed sufficient as exceptional grounds before this Honorable Court to warrant the grant of the relief sought, particularly the setting aside of the foreclosure order made on the 13th day of February 2025 and the substitution of its witness. Party submissions. Learned counsel on behalf of the second defendant applicant adopted its processes in support of the application and referred to paragraph 2 of the supporting affidavit deposed to by Mr. Nnamdi Ezenwa. Counsel submitted that the reason adduced therein, namely that the second defendant's witness number 1, Mr. Henry Ochenna Ezenwa, whose written deposition was filed on the 9th day of July 2021, is unable to come and give evidence in this case due to his unavailability, constitutes sufficient ground. This constitutes sufficient grounds, according to him, to warrant the exercise of the court's discretion in favor of the applicant. Counsel urged the court to grant the application in the interest of justice. He urged that substitution of a witness is a matter of routine, and the grant of the application will not prejudice the claimant or the other defendants. Counsel further objected to the claimant's further affidavit in support of its counter affidavit filed on the 21st day of October 2025, contending that the process is unknown to law and that he was not pleased with the language used in that process. Counsel for the applicant also submitted that by Order 11, Rule 1, Sub-Rules 1, 2, and 3 of the rules of this court, an application to call an additional witness may be made to a judge by motion or notice. He relied on the case of Enyem K versus Omela, citation provided, and case of Ejezi versus Anu, also citations provided, and submitted that Substitution is the replacement of an existing party to a suit with another person, and that such application is generally granted as a matter of routine. Counsel further submitted that the applicant has offered reasons to justify the indulgence of this honorable court in granting the application. He relied on the case of Mrs. Olufumilayo Ibironke Kasumu versus Alhaji Sikiru A, Sitita B, and 3 others. Citations provided. He submitted that the primary duty of the court in the exercise of its discretionary powers is to attain substantial justice. Claimant counsel, on the other hand, identified and adopted his processes in opposition to the application. Counsel submitted that on the issue of the further affidavit, it is certain law that a party is allowed to file as many further affidavits as possible, and that it is not alien to practice. Counsel argued that for an order to set aside foreclosure, the court must consider certain circumstances. He submitted that both the claimant and the other defendants have filed their final written addresses and have seen the case of each party. Granting the application, he contended, will prejudice the rights of the claimant and the other defendants. He urged the court to dismiss the application with punitive costs. Counsel further submitted that once a party has been foreclosed from leading evidence in a case, the discretion to set aside same is narrow. The law is settled that court's discretion can only be exercised if sufficient cause is shown. He relied on a case of NHDIP Limited versus Folarin, citations provided. He argued that where defendant chooses not to call evidence in his case, it is taken as having closed his case. Relying on Gazu versus EM, counsel argued that the record of the court clearly shows that even after the second defendant had been foreclosed from entering its defense, the second defendant's counsel equally informed the court that the second defendant would not be calling any witness in this suit. Having so elected, the defendant is bound and is stopped from resigning from this position, relying on the case of Ezomo versus Oyakiri. Counsel submitted that the applicant who seeks the exercise of the discretion of this court in his favor has a burden duty to place relevant materials by way of affidavit evidence before the court, relying on Haladu versus Access Bank, Williams versus Hope Rising Voluntary Fund Society, Ezewuka versus Ezenu Nujo, and the case of S&D Construction Company Limited versus Ayoko. Learned counsel contended that the second defendant has not placed before the court any material for the exercise of its discretion in its favor, pointing out that no reason has been adduced to warrant the exercise of discretion to set aside the foreclosure order made on the 13th day of February 2025. No reason was given on the 13th day of February 2025 for its failure to call its witness. No reason was given for the second defendant's voluntary decision not to call any witness in its defense. Now, no reason has been given for its intention or decision to substitute its earlier listed witness, who incidentally is the managing director of the second defendant, for a new witness of this time. At this time, the reason for the non-availability of the witness, who is the managing director of the second defendant, is not stated. The business relationship between the purported new witness and the second defendant for the purpose of the trial is not stated. The proposed witness statement is not exhibited for the court to consider the nature of the evidence to be given. Counsel further submitted that it is settled law that a party seeking the exercise of the equitable jurisdiction of the court must do so with clean hands, as he who comes to equity must come with clean hands. Furthermore, equity will not aid the indolent, relying on the case of socio-political research development versus Ministry of FCT 2019-1 NWLR Part 1652, page 313, paragraph C to D, at page 331, paragraph C to D. Council finally urged the court to dismiss the application with punitive costs, as the application is frivolous, vexatious, and an abuse of court process. On the part of first defendant, counsel for the first defendant submitted that although they have not filed counter affidavit, they are objecting on terms as the applicant was given enough opportunity to defend his case but choose not to. Counsel asks for a punitive cost of 500,000 naira should the court grant the application. On the part of the third defendant, the counsel informed the court that he is not opposing the application, but since he has filed his final written address he is asking for cost of 250,000. Sorry the interruption. I will take it again. I have carefully examined the processes filed by the parties, the written addresses, and the oral submissions of the counsel. The facts leading to this application are not in dispute. The second defendant is seeking, among other things, the orders of this court, setting aside the order of foreclosure made on the 16th day of February 2026, substitution of witness, and deeming the separately filed witness statement on oath of Ochinna Ezenwa as properly filed and served. The application was filed after the close of hearing of this case and was adjourned for filing and adoption of final written addresses. I will take the objection as to the competency of the process filed by the claimant. The second defendant's counsel objected to the claimant's further affidavit in support of its counter affidavit filed on the 21st day of October 2025, contending that the process is unknown to law. The claimant's counsel submitted that it is settled law that a party is allowed to file as many further affidavits as possible, and that it is not alien to practice. On the 28th April 2026, claimant counsel filed notice of authority that he relied on the case of Zenith Bank PLC versus Bankolands Investment Limited and another to support his contention. The court has carefully considered this objection. The fundamental principle governing the filing of further affidavits is that they are permissible only where they are in response to new facts raised by the opposing party in a reply affidavit, or to address new issues that have arisen from the opposing party's subsequent process. A further affidavit is not a vehicle for a party to introduce fresh facts that were available at the time of filing the original counter affidavit, nor is it a substitute for seeking leave to file additional process. In the instant case, the applicant filed its motion on notice and supporting affidavit. The claimant responded with a counter affidavit and a written address. The applicant did not file any reply on points of law or a further affidavit raising any new facts. Consequently, there was no new factual or legal issue to which the claimant needed to respond to. The case of Zenith Bank PLC versus Bankolands Investment Limited and another, cited and relied upon by the claimant's counsel, only support filing of further counter affidavit where new facts are introduced in a further affidavit of the applicant. The opposing party is entitled to file a further counter affidavit, especially when hearing is yet to commence. The claimant for the affidavit, therefore, was filed without any justification and without leave of court. It amounts to an attempt to introduce additional evidence and arguments out of time, which is an abuse of court process. The law is settled that a party cannot file a further affidavit simply because he wishes to. There must be a proper basis, such as reply raising new matters. See the case of Adebanke versus Ojilabi and the case of Odukwe versus Ogumbi. Accordingly, the court finds the objection of the second defendant's counsel meritorious. The claimants for the affidavit in support of its counter affidavit filed on the 21st day of October 2025 is hereby struck out as incompetent, irregular, and abuse of court process. The court will decide this application based solely on the original counter affidavit and written address of the claimant. Whether the second defendant applicant has placed a sufficient and exceptional grounds before this honorable court to warrant the grant of the relief sought, particularly the setting aside of the foreclosure order made on the 13th day of February 2025 and the substitution of its witness. This is the issue adopted by this court for the determination of the application. The court has carefully considered the submissions of all parties, the authorities cited, and the applicable rules of this court. Order 11, Rule 1, Sub-Rules 1, 2, and 3 of the rules of this court provides for the calling of additional witnesses. However, the exercise of the court's discretion under the rule is not automatic. A party seeking to call an additional witness, particularly one to substitute a witness on record, must place sufficient and cogent reasons before the court will warrant the exercise of such discretion. The law is well settled that once a party has been foreclosed from leading evidence in a case, the discretion to set aside same is narrow. The court's discretion can only be exercised if sufficient cause is shown. See the case of NHDIP Limited versus Florin, as rightly cited by the claimant's counsel. Furthermore, it is certain law that where a defendant chooses not to call evidence in his case, it is taken as having closed his case. In Gazu versus Iam, the Court of Appeal held thus at page 493, paragraphs A to B. A party is free to choose whether to adduce evidence in support of his pleading or not, and the court has no power to interfere with the exercise of that right. When a party makes a choice which the law requires him to make, and that choice was acted upon by both parties in the suit and the court, the party who made the choice cannot turn around afterward and claim that he has made a mistake. See the case of Akambi versus Alao. Having so elected to close his case, the second defendant is bound and is stopped from resigning from this position. See Ezomo versus Oyakiri, where the court held thus: a person who is under no legal disability and having full knowledge of his rights and or interests conferred on him by law, and who intentionally decides to give them or some of them up, cannot be heard to complain that he has not been permitted the exercise of those rights or that he has been denied the enjoyment of those rights. In the instant case, the record of this honorable court clearly shows the following. The second defendant was foreclosed from entering its defense on the 13th day of February 2025 due to its absence and the absence of its counsel in court. Even after being foreclosed, the second defendant's counsel on the 12th day of May 2025 expressly informed the court that the second defendant will not be calling any witness in this suit. The second defendant did not give any reason for its decision not to call any witness. The second defendant counsel went on to cross-examine, sorry. The second defendant counsel went on to cross-examine the third defendant's witness on the 16th day of July 2025. The case was adjourned for adoption of final written address, and parties, including the second defendant, had filed their final written address, including the first defendant, had filed their final written addresses. It is only after the case was slated for adoption of final written addresses that the second defendant brought this application. The court finds the second defendant's conduct to be indicative of lack of diligence in the prosecution of its case. The court notes the following factors. The second defendant's indolence, that is, he has demonstrated a consistent pattern of tardiness and indolence in this suit. The second defendant voluntarily elected not to call any evidence in proof of his defense and willfully closed his case. The law is that the law will not aid the indolent. A party seeking the exercise of the equitable jurisdiction of the court must do so with clean hands. See the case as rightly cited by the claimant, Socio-Political Research Development versus Minister of FCT. The second defendant's hands are tainted by its consistent indolence and lack of good faith in these proceedings. The application was brought after the stage of proceedings. The application was brought after the second defendant had been foreclosed, after it had voluntarily elected not to call evidence, after it had participated in the cross-examination of the case of the third defendant's witness, after parties had filed their final written addresses, and when the case was slated for adoption of addresses, final written addresses. To grant this application at such a late stage will cause significant prejudice to the claimant and other defendants who have diligently prosecuted their case. The applicant's supporting affidavit deposed to by Mr. Nnamdi Ezunwa is devoid of sufficient material facts to warrant the exercise of this court's discretion. The affidavit merely states in paragraph 2 that I know that the second defendant witness number 1, whose written deposition was filed on July 9, 2021, is unable to come and give evidence in this case. Again, due to his unavailability, hence the need to bring in another witness in his place, quote and unquote. The affidavit does not disclose the reason for the non-availability of the witness, who is the managing director of the second defendant. The efforts made to secure the attendance of the said witness, why the witness was no longer available, the business relationship between the purported new witness and the second defendant, why the new witness should be allowed to substitute the witness on record, the nature of the evidence the new witness intended to give, though separately filed, but not attached on the affidavit as exhibit. The law is that an applicant who seeks the exercise of the discretion of the court in his favor has a burden duty to place relevant materials by way of affidavit evidence before the court. See Haladu versus Access Bank and host of other cases referred to. The second defendant in this case has therefore failed to discharge this burden. On the issue of substitution of witness, it is my opinion that the Onyeka versus Omela cited were out of place. Those cases dealt with the substitutions of a party to a suit, not a witness. The substitution of a party to a suit is governed by specific rules. Under the National Industrial Code of Nigeria Civil Procedure Rules 2017, it is typically based on death, incompetence, or transfer of interest. The present application seeks to substitute a witness, not a party. While the court has the discretion to permit a party to call additional witnesses, the exercise of that discretion must be based on sufficient grounds. In this case, the second defendant has not shown any exceptional circumstances to warrant the exercise of such discretion. On prejudice to the claimant, the claimant instituted this suit in 2014 and has diligently prosecuted its case till date. The case has been in the docket of this court for over 11 years. Hearing commenced de novo on the 9th of July 2024. The case is at the stage of adoption of final written addresses. To grant this application will cause unjust prejudice to the claimant, who has waited for over a decade to have this matter finally determined. The court also notes that the claimant has been diligent in the prosecution of this case, unlike the second defendant. In conclusion, therefore, it is the decision of this court that the second defendant applicant has failed to place sufficient and exceptional circumstances before this honorable court to warrant the setting aside of the foreclosure order made on the 13th day of February 2025. The application is an attempt to delay the proceedings and overreach the claimant, and was brought at a very late stage of the proceedings, after parties had filed their final written addresses and was slated for adoption of addresses. The loan issue in this matter is therefore resolved in favor of the respondents against the applicant. Accordingly, court makes the following orders. The claimant's further affidavit in support of its counter affidavit filed on the 21st day of October 2025 is hereby struck out for being incompetent and abuse of court process. 2, the order of foreclosure made on the 13th day of February 2025 against the second defendant is hereby affirmed. 3, the second defendant applicant's motion on notice filed on the 1st day of September 2025 is hereby dismissed in its entirety. Parties to bear their respective cost, ruling entered. So that's the ruling of the court.
As the court pleases. My Lord, we're grateful for that well-detailed ruling.
Yes.
As the court pleases.
Yes.
As the court pleases. Well done, my Lord.
All right. I wish you a pleasant weekend.
Thank you, my Lord.
Thank you, my Lord. My Lord, I don't know, in view of the ruling that has just been delivered, are we coming back for adoption? We are supposed to come back for adoption of our addresses since it has been filed. I don't know if anybody can hear me.
I'm hearing you, my Lord. The claimant is asking you a question, my Lord. Hello, my Lord.
My Lord, we need a date for adoption.
Yes, my Lord.
Don't worry, I will talk to him and get back to you guys.
Thank you very much.
Okay, thank you. That's fine. Thank you, Mom.
Thank you very much.
Have a nice weekend. Bye.